All right, still with me, criminal defense attorney and former prosecutor David Bruno. Big moments today inside that New Jersey courtroom with, first of all, Lauren Kanarek, the alleged victim who was shot twice, finished up her testimony. Then she was almost immediately preceded by her fiancé, Robert Goodwin, who we were just watching. And, you know, I really thought the moments where he was describing, David, the shooting and what he was remembering about what the defendant was doing, where he was, he became emotional. I thought that was powerful. What are your thoughts?
Sure, but let me first start. I mean, I've prosecuted homicide cases in that county. I was a major crimes prosecutor out of Morris County. I'm in New Jersey, and I regularly practice there, and I know the players too.
Oh, that's great.
I mean, look, this is going to be interesting as it continues because there's two affirmative defenses at play. There's insanity, meaning that there's a mental defect that affected the defendant's right from understanding right from wrong. And then there's self-defense, that he acted reasonably and used deadly force because he thought it was necessary to protect himself from death or serious bodily injury. And unlike the Mosley case, that's not on video. So Mr. Belinkis here is cross-examining and making some points on both sides of his defenses, because ultimately I think it's going to come down to the doctor, in a sense that, look, self-defense is going to be very difficult here because this individual uses a gun, shoots the alleged victim twice in the chest, and then attempts to shoot the male, and there's no other weapon there, right? So when you talk about self-defense and reasonably necessary to deter that force, that's going to be a tough argument. So we are left with the insanity defense, where it's going to be a psychiatric evaluation. A forensic psychiatrist is going to come on the stand and opine that the individual, based on all the defendant, based on all the abuse of these two individuals, the two alleged victims, rose to a level of a defect, a disease that prevented him from understanding right from wrong. And that's what's happening in the cross-examinations. While the testimony is emotional, and both victims here, they had to explain many things, many inconsistencies. The victim, the female victim, has social media posts out there that are very questionable and threatening in nature. And that is really what the defense is here, that there was so much pressure put on the defendant by these two individuals that it drove him to do this.
Right.
And in the case, they have two defenses, self-defense and insanity. Yeah. And really, that's where this case is going.
Yeah, I'm so thankful that you've practiced there, that you're familiar with the law there, because that has really baffled a lot of legal analysts' minds and the experts that have been coming on Court TV, that there's this two affirmative defenses being put forth. And our research shows that until 2013, there you had to have a bifurcated trial if you wanted to claim insanity and self-defense. The Supreme Court there overruled it. It was State v. Handy in 2013. It had to be done at the same trial. So if you could, in your expertise, speak to how that actually works and explain it to some people, that how can you say that you were exercising self-defense but also mentally insane?
Sure. I mean, they really don't, they're not consistent. So I see either one, and really it breaks down to whether or not the evidence can support the theory of defense. You can't just, in New Jersey, you can't just allege affirmative defenses and not be supported by evidence. So at some point, there's going to have to be enough evidence to support each for it to go to the jury. There's still going to be that factual determination by the court. There has to be evidence to support each. And I can't see them bringing back both a self-defense and insanity defense for the jury, but for the defense, well, they're arguing two different things. Maybe one works, maybe one doesn't. It's really the benefit to the defendant here that he has both options available to him right now.
Oh, absolutely, and you're so right on cross. The defense attorney really doing a masterful job drawing out those high points for their theories of the case. David Bruno, thank you so much for your excellent insights there. Coming up, we're on this Barisone.